Welcome back to Legal Services Podcast with me, SamPawson. Joined us by Nils. Nils, how are you?
Very good, Sam, you?
Good. New setting. We seem to have a new setting each week. I think the grandest of our settings. Fireplace in the background. And it's also our last podcast before the summer hiatus.
Yep.
So, both two young children, so both time away, school cover, so a bit of a break until September. But lots to talk about today. Both got some interesting data. You're kicking us off, Nils?
Yes, so some right to work updates from me and a really big change and one that's coming up soon as well. Yeah. So 1st of October, there's going to be an expansion of Section 48 of the Border Security, Asylum and Immigration Act beyond, I would call the traditional, if you like, contracted employee. So it's going to expand beyond those contracted employees to workers.
Yeah.
So that's going to be broadly where someone's an individual performing work personally, and the party with which you're contracting with is not a client or customer of your own business.
Yeah.
An individual subcontractor, a contractual chain, and also through an online matching service or platform that matches service providers with clients or customers for free or commission. So that is pretty wide. What this is going to result in is what I would call extended liability. So you might have a situation whereby you are engaging with a particular organisation and someone is higher up the contractual chain than you are. You could still be liable for that company in terms of if they don't have the right to work in the United Kingdom. So that's going to have quite a profound effect. The way I think about this is reasonably similar to how we looked at IR35. You've got these contractual chains, and these might be quite complicated chains, and you're going to have to work out where you sit in that chain and whether you need to do a right to work check. I also think this is going to have corporate law consequences, in that you're going to have to put in a commercial contract that other party needs to carry out those right to work checks. I will need to speak to our corporate colleagues whether you want to limit liability in those contracts as well. If you're genuinely self-employed and in business on your own, in your own name, and contracting directly with that party, then you would be outside of scope. My mind did go back to last week when I was having some windows fitted. The person fitting the windows was not the person that I'd engaged with. Now obviously that's an individual contracting with a company. But if that were a company contracting, if we were having some windows fitted here, it's that type of scenario that may well be caught by the new regulations. So questions to ask is, when you're looking at that person doing the work, do they have to do that work personally? These are all the same questions we asked in IR35. Can they send someone else? And how is that substitution actually going to work? Is someone genuinely running their own business with their own clients, their own equipment and their own commercial risk? How integrated are these individuals into your workforce, into your service delivery model? And if you're going through a platform rather than a supply chain, are you contracting as a customer with an independent business? Quite a bit of risk there going forward. But again, being part of the business to make sure that people we're contracting with actually have the right to work in the United Kingdom. So lots of food for thought there, and that will apply across the board, I think, to many of our clients.
Yeah, I agree with you. Huge changes, I think. A lot of added bureaucracy, and for, as you said, the example you gave was a really good one. Someone coming in to fix a window, to fix a door, to do the fire alarm. If it needs to be those checks carrying out for what might be half a day's work. So big impacts, I think, from the workers to employees. Again, it's narrowing the gap, I think, between this what was used to be quite historically established employees. This is what you would require for employees. I think those lines are seemingly blurring, that you almost treat everyone like as you would an employee. So it's that full induction piece at the start. Again, lots of added burdens. be interesting to see how it's enforced, and penalties for the lack of checks being done. Some blurring the lines between what is practical and legal. So interesting one.
It is, yeah, and we'll keep an eye on it. I'm sure someone will get stung by this, and as soon as we see that, we'll let everybody know.
Yeah. Similar vein for me, Nils. Conscious of the break in the podcast. Equally, I wanted to just summarise some of the changes coming in October, because by the time we're back in September, those changes will be less than a month away. So 3 summaries for me in terms of key changes coming in October. First, there's a raft of changes in relation to trade unions. And greater powers and access of trade unions all coming in force in October. So quick summary of them for me. There's I think 5 main changes that organisations need to be aware of. So first is a duty of a company to inform employees of their right to join a trade union. That's on day 1. So for kind of new starters, for employees, companies will need to be coming up a way with informing employees, whether that's an information sheet, whether that's something on the intranet, just some way of this is your rights to join a union, these are who you can contact. And that's whether the organisation recognises a union or not.
Right.
So again, another administrative change that needs to be coming quite quickly. There is quite a dramatic change in the union's ability to access workplaces, again to inform employees of their rights in respect of joining trade unions. So if you were to receive a request from a trade union to enter your premises, to be able to have an opportunity to speak to employers, you need to facilitate that request. Again, we'll need it'll be interesting to see how that is done and managed. I would imagine you put your move aside for them, informing your employees that the union is there and that they have a right to pop down and see them. There is notice requirements, so they can't just turn up unannounced, but similar to inspection, regulatory requirements, they're going to have to tell you they're coming, but then you can't unreasonably refuse that. So again, we'll see how that plays out in practice, how much that is done. Again, applies all of these rights apply whether the company recognises a union or not. Even if you recognise a union, other unions can request access. So whether this will create a kind of competition between unions, we'll see. An interesting one, a new right for reasonable accommodation and facilities for trade unions carrying out their duties. So probably this is more where you do recognise a union and you're going through a consultation exercise. If that's on site, you'll have to provide accommodation and access for the unions. A new right to time off for union equality representatives to carry out their duties. So again, similar to time off for jury duty or other time off requirements, that will become an established time off. And there's going to be an updated code of practice on trade union recognition and how that process works. So quite a lot of changes there, and some, I think some quite, fundamental new rights. I think especially the access and the informing your employees, that will be very new for a lot of organisations. Organisations where you establish and you recognise with trade union, I think probably won't see as much change. But those many organisations who don't, I think there's some big changes. I'll pause there. Nils, on trade unions, any views on that?
I don't know the answer to this. I don't know if you do as well, so maybe an unfair question. What's the consequence if you don't on day 1 let somebody know?
Again, don't quite know the penalties. We'll see how it plays out. I believe it's going to be a kind of fixed penalty notice for you not providing or kind of day 1 that information. What I'm not sure, and we'll have to see what plays out, is what is the escalation process of employees informing the union probably that they've not been advised, and then it'll be for the union on behalf of that individual and the individual to pursue that. I think it will be very interesting come October how often this is done. If it's done at all, it becomes a bit of a something that it isn't enforced a lot, but it's going to be there. Next change we have talked about in the past, quite a big change, the change in the limitation period for a lot of employment tribunal claims from 3 to 6 months. So we talked about that in previous podcasts. A big change in terms of probably the amount of claims being brought into tribunal. One, I think the context of how busy the tribunal is, this is going to cause even more pressure on the tribunal. Purely as a concept of equity for me, I can see the rationale in this. I think you look at limitation periods in all other jurisdictions for 6 years. 3 months has always seemed very tight, especially where you've got disability claims with potential ill health. And there's a lot of claims that do get extended on kind of just an equitable ground. So I think this hopefully will mean more claims will be brought in time rather than having to make that just an equitable extension. So I think it has some sense, but again, it's only going to result in more claims.
Yeah.
So interesting one. I don't know again any thoughts on that one.
Just be interested to see if any further resource gets put into the tribunal. There's going to be more judges, more courtrooms, everything. And certainly since I've been in practice, I haven't seen any expansion of that.
Lastly, and again, one we have touched on, but it goes to both our kind of areas of practice, is the extension on sexual harassment and to include third-party harassment, which I think we're both old enough that third-party harassment used to be in when we first practiced. They're bringing that back, as well as that change to the general sexual harassment claims that employers must take all reasonable steps. So again, one that is potentially a massive change. One that I think the reason for talking about it today is that listeners, companies need to take action now, especially on third-party harassment. Hopefully they'll have procedures in place about taking reasonable steps to prevent harassment, so that all is just going to heighten that. But really for companies to look at that risk profile when it comes to your employees dealing with third parties, so suppliers, customers, general members of the public. So especially if you're in retail, you're in hospitality, really going to be a big process to look at that risk assessment and to say, well, where are our risks? Where do our members of staff potentially come into concern and look at the piece and trading piece and policy piece about how we're going to protect them. So again, another huge change coming up.
Yeah, it's a bit like health and safety that we do. If you can show one thing that you could have done, it's game over.
Yeah, which I think I agree with you. That's my kind of summary, that strict liability almost. I think that leads. I think I've had conversations with individuals and it says, well, if there's almost no defence, why do we even bother trying to do it? I think for me, it's more of yes, you need to take all those steps you can, but ultimately, if you are ending up in defending a claim, I think both of our experience will say it's going to be incredibly difficult to successfully defend your claim, because for me, if there's all reasonable steps, that means is there anything foreseeable that you could have done? Is that not an all reasonable steps? Again, it's going to be very interesting, the first few cases that come through the tribunal to test that. But it's again probably not the best news for employers. But again, bigger picture, you can see, we're trying to cut out abhorrent behaviour, which is sexual harassment. So, a bit like when we talked about right to work and legal working, it's something that is you can see the reason for it. It's just what burden and impact is that going to have on companies that may not be as well considered.
Yeah, absolutely.
So, as promised, action-packed, lots of updates. We're going to have a break over the summer, but we'll be back again with a lot in September, really. From my perspective, working towards January, where we've got a lot more changes. I know in your world as well, lots of things to come.
Absolutely, looking forward to it.
So, yeah, for me, Nils, have a wonderful summer. We probably see each other occasionally, but not on the podcast. So, thank you to all our listeners. As always, please continue to like our videos, to subscribe to both the podcast and the Monday Morning Dispatch. Details on our LinkedIn and on the YouTube page. So thank you all for listening over the last year, and we'll be back in September.
Thanks, have a great summer everyone. Thank you.